Welcome back to another courtroom breakdown because today's case is one of those hearings that reminds us how quickly a person's choices can spiral into life-changing consequences. We begin with a defendant who's been sitting in custody for months, unresolved lab tests, probation issues, and a judge already familiar with a long criminal history. But this isn't just about one mistake, it's about patterns, accountability, and whether the justice system should extend another chance. As this hearing unfolds, we'll see difficult questions raised. How long should courts wait for evidence? When does rehabilitation stop working? And at what point does a judge lose trust in a defendant entirely? Stay with us because this case delivers everything: legal debates, emotional moments about family and children, and a final ruling that could change lives forever. By the end, you'll have to decide for yourself. Was justice served, or was this the inevitable result of years of poor decisions?
Adam Dixon? I'm sorry, sir, you're not Adam Dixon. I called Adam Dixon and you show up.
Well,
Do you look like, are you portraying Adam today?
I will represent it.
All right, what are we going to do today?
I represent Adam all the time. Judge Burnett has now been in custody for 5 months. Where'd you go? It's a 5/5 TRP.
Yeah.
He has not been indicted on the three cases that make the primary basis for the allegation of the motion. And so
He doesn't have to be for me. I mean, I'm not going to wait on it. We're going to deal with it. I'm not going to wait on those. I mean, they're mostly through probation. They're the part of it.
they haven't been able to test the drugs since the issue, Judge.
Okay, well, then y'all are ready, is what you're saying, or he's saying.
We do not have the drug test back.
Well, those are the substantive issues.
Right.
I mean, but that's what I'm going to deal with.
Mike,
This motion to revoke probation is what we're going to, which is what we're going to deal with first. And then whatever happens on this is what happens on this. But this first degree felony is that. We'll take it up next.
Yeah, we're going to need a reset so that we can get those drug test results, Judge.
Where are they?
Yeah.
In the great scheme of things. Do we know?
I don't know.
It's being tested. It's in the process.
Okay. What does that mean, do you think?
I don't know.
Weeks, not months?
Probably weeks. I would give it weeks.
Because it's got to be reviewed.
Yeah. Even if they test it, they've still got a review process. They got to verify the results.
Committed the offense of illegal possession of a controlled substance. What?
This moment highlights an important legal issue that many viewers may not realize. Courts often rely on lab testing to confirm substances before making major decisions, especially when probation violations are involved. The defense wants more time because the drug test results could potentially change the picture, while the judge is balancing the need for fairness against the need to keep the case moving. This is one of the toughest aspects of criminal law. Justice delayed can become justice denied, but rushing without evidence can also be unfair. What do you think? If someone has already spent months in custody, should courts wait for every lab result or move forward with the evidence already available?
What is that? It's not listed. It is an abstract substance.
It
It's going under pseudonym.
Yeah,
What is it?
white rock crack cocaine.
That's over 17. Don't have any substance to go to 10. Verification form, community service. How are we doing from probation? Thank you, ma'am. He's been on probation with August 28th. From August 28th. When did he go into custody?
It was January 12th.
He's been in custody since the first of the year?
Yes, Judge.
Okay.
And Judge, we previously filed a motion to set a bond. I understand that the straight probation, he's not entitled to a bond. The court at the time initially denied that. I'm just asking the court to consider revisiting that since we are going to have to reset this.
Here's why I object.
I know, don't.
Don't look at it.
Skip those 3 pages in there.
Right. But again, Judge, that hearing was 5 months ago. This is now May, or reset and longer. So we'd ask the court to consider. I'm aware of that.
The first, the juvenile court history really doesn't matter to me unless
But it continues
he
past that. Yes.
um, he gets transferred to adult status. Then you've got
And I don't know how Mr. Burbank talked into probation on the first place, but he did.
your age, sir.
38, sir.
I'm looking at just for the purposes of the record.
When a judge begins reviewing criminal history in detail, that's usually a sign that trust is becoming a central issue in the case. Criminal records don't automatically determine guilt in a new matter, but they absolutely influence decisions about probation, bond, and risk to the community. Here, the court is looking at patterns rather than isolated events. That's significant because probation is built on the idea that a person can follow rules outside of jail. If a judge sees repeated violations over many years, it becomes increasingly difficult to justify another opportunity. The question is no longer just what happened, but can this person realistically change? That's a much harder question to answer.
The most prolific criminal history. Prolific. Because in your, including juvenile court history, adult misdemeanor court history, and adult felony court history, how many cases were involved here in that? Do you know?
Sorry, Judge. I've been instructing him to answer any questions, but I'll
But
what do you mean? How many?
How many cases? First of all, there are 50 filed cases. There were 50, and out of that number, many dispositions. Not the least of which are 9 or 10 felony court dispositions, not including the misdemeanors. In addition to that, on the other criminal matters, which for the most part are Class C misdemeanors, 100 Class C misdemeanors, 100. So what jumps out at me is this is a far greater than normal criminal history that is
50 filed cases. Think about that for a moment. Even if not every case ended in conviction, hearing numbers like these immediately changes the atmosphere of a courtroom. Judges often emphasize that everyone makes mistakes, but when mistakes become repeated patterns, the court starts seeing risk instead of coincidence. The judge here is carefully distinguishing between allegations and actual dispositions, which is important legally. But at the same time, he can't ignore the overall history. This is where probation cases become especially difficult. They're less about proving a new crime beyond a reasonable doubt and more about whether someone has honored the trust previously given to them. Would you still grant another chance under these circumstances?
That is generally dealt with, which reasonably, by reason, there is a propensity to make the wrong mistakes. I have you here on 2 probations, right? And
Just one.
whether there's
That's a different
and this is the new case, isn't it?
No, there's no new case. It hadn't been filed yet.
Theft.
That's
Correct.
me, Judge. That's a different.
That's a different one. That's the next one he's got. That's the next Mr. Gertz has coming up. That's not Mr. Dixon. Mr. Dixon only has one case pending right now on interpret.
Sorry. Okay, on, just from Mr. Dixon, not, what's this? Sabrina. On Mr. Dixon, I remember, I can't remember everything distinctly, but I do remember the prolific number of criminal matters. And actually, I mean, I'm very sensitive about the fact that many of these aren't dispositions, criminal dispositions. So you throw that out of the mix, but still a lot. And then we've got you on this third degree felony, and and it's how you deal with your problems that is the real test. Everybody makes mistakes. Some people make more than the normal number, but everybody makes mistakes. It's how you deal with it. And in here, in this case, this crime that you were placed on probation for, you didn't deal with it well. And then they're booking you in, and then for evading arrest, and then the crack rocks start falling out of your orifices, or your pants, your underwear, whatever it is. I mean, you can't make this stuff up. It's just compounded. When you're in a problem.
You can hear the judge's frustration here, and it's about more than just the alleged conduct itself. Courts often expect defendants on probation to avoid situations that create additional legal trouble. The judge's comments reflect a common legal principle. Actions after an arrest can sometimes worsen perceptions of responsibility and judgment. What's striking is the emphasis on decision-making. The court isn't simply asking whether laws were broken. It's asking why the same patterns continue repeating. This becomes especially important because probation is designed as an opportunity to avoid prison through compliance. When someone repeatedly finds themselves back before the court, judges begin questioning whether probation is accomplishing its intended
When you're
purpose.
in a problem, fix it. You got to fix it, responsibly. And for whatever reason, you should have known that sooner or later they were going to get to the bottom of everything. And I literally used the bottom here. They were going to get you for something more, and that compounds a fact situation, a circumstance of this particular offense. And so you plead guilty and promise, really, to me, we'll never do this again. I'm not going to get in any trouble. That's number one. And so it's alleged that less than 2 months later, you're committing an offense. Right? That's what it says, which disappoints me. But it's got to disappoint you because you're the one that's going to pay for this. I just don't know how to trust him. That's why I'm reluctant to get him in a position where he can be released under these set of circumstances when we're still waiting on some lab results.
Yeah, plus when you released him under conditions of probation, which would be similar to bond conditions, he couldn't make it 2 months. So, or he's arrested.
Anything else?
Yes, Judge.
Go ahead.
There are reasonable conditions under which you could place him in GPS.
There are reasonable conditions.
I just don't know how to trust him. That may be one of the most powerful statements a judge can make during a probation hearing. Trust is the foundation of probation. The court allows someone to remain free under conditions because it believes they can follow rules and avoid further trouble. Once that trust is damaged, even alternatives like GPS monitoring or home confinement become difficult to justify. The defense is arguing for supervision instead of incarceration, which is a perfectly valid legal strategy. But ultimately, the court must weigh public safety, past conduct, and future risk. Here's the big question for viewers. Should technology like GPS monitoring be enough to earn another chance? Or does repeated noncompliance outweigh those safeguards?
GPS home confinement drug patch, and setting us significantly high enough bond to ensure the undertaking, which is what the law asks us to do. And
The law does say that it's not required under these circumstances.
I understand, yeah, but I'm asking the court
But
because of
let
length
me
of.
just say this, another offense under this situation, committing another offense would be, what would be the term? Catastrophic for you. But it wasn't catastrophic enough when you were put on probation to keep you from coming back in here. Presumption of innocence always being part of the equation.
We're just asking the court to consider that, the time that's gone by since this incident.
And is there any word at all from the lab about when this is expected to be
There
done?
won't be, Judge.
Is there a way
we don't-
we can hasten it?
I can try, Judge. I can't make any promises because we've got
What I'd like you to do
more
is
than one
try
county.
before I'm not going to grant the relief yet.
Yes, sir.
Let's see what they say. If they say it's a long time, then I'll read
And we
it.
read
You
that
look at it
and
and
revisit it and say 3 weeks, Judge.
They ought to have an answer in 3 weeks. But at the end of the day, what are we doing with it?
Well, Judge,
Now,
I don't know
what
what
are you
these
gonna
tests are going to say, Judge. I don't know what it's going to say. And I'm happy to presume that my client is innocent. So
I know that, but you have confidentiality with him. You know what the answer. He knows what the answer is. You know what the answer is. It's just whatever. But he knows what the answer is, and what needs to be done is you got to get out of this tailspin and fix this. You have family at home.
Yes, sir.
Do they depend upon you?
Yes, sir.
They're not getting help with you in jail.
No, sir.
Do you have children?
Yes, sir.
How many?
4.
What's the greatest gift you can give your child? What's the greatest gift?
Time.
A good example.
Okay, so.
They're going to do just
This
what
is where
you do.
courtroom proceedings stop feeling like legal arguments and start feeling deeply personal. When the judge asks about family and children, he's not just making conversation, he's highlighting consequences that extend far beyond the defendant. The justice system often focuses on accountability, but judges also understand that incarceration affects entire families. For children means 4 young lives potentially impacted by every decision made in this courtroom. The hardest part? The judge isn't simply talking about punishment, he's talking about legacy. What kind of example do children see when a parent repeatedly ends up in legal trouble? That's a difficult question because the effects of these choices often last far longer than any sentence handed down in court.
They're going to do just what you do. What I'm telling you that is don't expect them not to make the mistakes you're making because it's a natural phenomenon, the way our creator made things. The parent figures are directly influential to the children and they're growing up and they're shaping of their decision making. You're not making good decisions for your parent, are you? You're supposed to be out there working, making a family, a unit. You're in jail. And they're going to, the kids are going to go, hey, Dad, it's good enough for Dad. The point is, you're not just hurting yourself. You got people who depend upon you. You're touching their lives directly, and you're not touching it in a good way, which can be changed any moment if you wanted it. That's what's the shame. We'll see you back in 3 minutes.
The judge's comments about being a role model strike at the heart of something many people forget. Criminal cases rarely affect only one person. Research consistently shows that children often mirror the behaviors they grow up observing. The The court is essentially making a broader point about responsibility, not just legal responsibility, but parental responsibility. What's interesting is that the judge also leaves room for hope, emphasizing that change can happen at any moment. That's an important reminder. Courts punish conduct, but they also hope for rehabilitation. The real question is this: how many opportunities should someone receive before society decides enough is enough? There are strong arguments on both sides.
Larry Johnson, what are we gonna do?
Sure.
Larry Johnson, what are we gonna do on that? How'd that go?
Yeah, we got the results back of like 233. I think that we could be true and obviate the necessity of proving that.
Is that what you want to do?
I said that we could obviate the necessity of proving up the lab results since you did get them back and they were 233. That's right. And then we proceed on the basis of being true.
Larry Johnson? Talk to him about being ready for this.
It's point 233.
We now call cause number 19-33338. The state of Texas versus Larry Gene, thank you, Johnson Jr. That is you. Your attorney, Mr. Kindler, and the state's attorneys are present. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation filed on January 9th of this year? Can we proceed in Senate? Wow. And Mr. Johnson, you've had a chance to discuss this with Mr. Kindler. You understand what you're charged with here? Yes. Okay. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God. Yes. Lawyer. In summary, sir, this motion to revoke unadjudicated probation states that on June 20th, that's a special day for me, by the way.
What is that, Sean?
Yeah, 2022. You were placed on 10 years deferred or unadjudicated probation for the second degree felony of aggravated assault. Is all of that true and correct? Yes. It's a special day for me every year on that day.
My birthday is the 22nd. So.
June?
Yes.
I may change my birthday, you know that. Actually, we're opposite sides. The first day of summer is the 21st.
Right.
Well, mine was the day before and this was bad.
Yeah.
So I'm just 2 days older than you. What?
Sorry.
I heard that.
Do we need to call EMS?
Yeah, I think just gagging. Back to this, which is not to make light of this, but it's unusual that because our birth dates are close by, we always make a deal about it when that date comes up. Do you understand, though, the seriousness of this case that we placed you on probation for in the first place, sir? Yes. And just to, I know you don't have to be reminded because I know you're a smart guy. You are. And I'm just very disappointed that we're back because I felt good about you fixing this mess and moving on. But this was the indictment pleaded that you intentionally and knowingly and recklessly caused serious bodily injury to another by cutting and stabbing that other person, which was an event that was capable of causing serious bodily injury or death, which is why it's treated seriously as a second-degree felony, aggravated assault.
Now we transition into an entirely different case, but notice how the court immediately emphasizes the seriousness of the original offense. Aggravated assault isn't a minor charge. It involves conduct capable of causing serious bodily injury, or even death. That's why probation in these cases is often viewed as a significant second chance. When courts grant deferred adjudication, they're effectively saying, we're willing to give you an opportunity to avoid a conviction if you follow the rules. But that opportunity comes with strict expectations. The stakes here are enormous because violating probation doesn't just mean facing consequences for new conduct. It can reopen the door to punishment for the original felony itself.
Okay. Number one states you committed the offense of driving while intoxicated on or about December 26th, the day after Christmas, 2025, in Jefferson County, Texas, in violation of condition one of your deferred or unadjudicated probation order. Is that true or untrue? What happened in that case? Was there a misdemeanor case filed out of that?
There is, Judge.
What's the status of it right now?
It's relatively new, Judge.
Go ahead, Mike.
I'm sorry, man.
I would think it would be enhanced. This is a point 223, so it'd be class A.
Let's say is correct.
Okay. Are you pleading true to allegation one by voluntarily and because it is true as it is alleged?
Yes.
Do you understand that a true and correct pleading of true to one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked. You can now be found guilty and sentenced to the second degree felony of no less than 2 nor more than 20 years confinement in prison. Knowing that, do you insist on
This
pleading
is
true
one of the
to
most important legal moments in the hearing. When a defendant pleads true to a probation violation, the legal landscape changes dramatically. Unlike a criminal trial requiring proof beyond a reasonable doubt, probation revocation often relies on a lower standard known as a preponderance of the evidence. In simple terms, the court only needs to believe it's more likely than not that the violation occurred. By admitting the violation, the defendant gives the court sufficient grounds to revoke probation. That's why judges spend so much time confirming that these pleas are made knowingly and voluntarily. Once entered, the consequences can be
that? Do
life-changing.
you insist on pleading true today?
Yes.
I find you pleading true voluntarily. You understand and appreciate the consequences of truth.
They said, my staircase, second floor, starting with the first period,
Looks like all these allegations are derived from that event.
That's correct, Judge.
So number 4 goes on to state you were at a location other than your residence at approximately 10:52 p.m. on or about December 26, 2025. That's important, correct? Because your probation order states you have to be in by 10 o'clock p.m. Is that right? Yeah, be inside your home between 10 p.m. and 6 a.m. That's your curfew. Is that allegation true and correct as it is alleged?
Yes.
And are you pleading true and correct to that voluntarily and because it is true?
Yes.
Curfew violations might seem minor to some viewers, but in probation cases, details matter. Probation conditions exist for a reason. They're designed to reduce risk and encourage stability. A 10:52 p.m. violation may only be 52 minutes past curfew, but courts often look at what the violation represents rather than just the time itself. Combined with allegations involving alcohol, the court begins seeing a larger pattern of noncompliance. This is where probation becomes unforgiving. It's not always one major mistake that leads to revocation. It can be several smaller decisions that collectively convince a judge that supervision outside prison is no longer working.
All right, there is no agreement here. Okay, may I see a few cents for you? Thank you very much. We'll take this on.
I don't know. I was a little slow today, Judge.
Very good indeed. So it looks like on your felony court history, you were placed on probation back in 2004 for illegal possession of a controlled substance. for a 2-year state jail, suspended for 4 years. That was revoked in 2009. And you were sentenced to 8 months in the state jail. Is that true?
Yes.
Okay. Then there looks like another, that's odd. On 3/23/2009, you also received a sentence of 6 months confinement in the state jail for illegal possession of marijuana. So is that true?
Yes.
Okay. Okay. That's your 2 felony convictions.
Yeah.
That's all you have, right?
Yes.
And then the misdemeanors, possession of marijuana in 04 again, possession of marijuana in 13. Marijuana was kind of getting you in trouble in the misdemeanors. And on Mr. Johnson's time accrued here, can you help me on that?
Yes.
Okay, so we're looking at no less than 2 nor more than 20 years confinement in prison. On this DWI, the probable cause thing, I see what the circumstances are. There it is. Oh, 0.223.
Mr. Harris showed it at the lab report.
But it actually matches the portable breath test you're using in the probable cause, right?
On this, let me see. The activated assault.
The court is now digging deeper into the history behind the original aggravated assault, and context matters. Family-related conflicts are often among the most emotionally charged cases courts handle because personal relationships can escalate into dangerous situations. But notice something important. Despite moments of humor and casual conversation in the courtroom, the judge never loses sight of the underlying violence involved in the original offense. Courtrooms can sometimes appear relaxed on the surface, but beneath those lighter moments lies the serious task of deciding someone's future. It's a reminder that legal proceedings often balance humanity with accountability in ways many people never see.
Okay, the complainant in that aggravated assault that you placed on probation, he was an ex-relative of yours? It says ex-brother-in-law?
Yeah, my kid's mother, brother.
Well, that's hard to follow, isn't it?
The what?
Your
My
children's,
kid's mother, brother.
Well, what?
oh, that's your,
what is it? Is
your
it?
brother-in-law.
Well, if they had been married,
We wasn't married, and we weren't even together. So,
there was no.
Oh, if you were married, it would have been a
Yeah.
brother-in-law. Okay, it was a quasi-brother-in-law, I guess.
Pseudo brother-in-law.
Can you even spell pseudo?
PSEUDO.
Very good.
I didn't hear you pronounce a P in that word. So y'all weren't common law married?
no,
Okay. That would have been a brother-in-law then,
yeah.
if y'all put that. Okay. Hmm. All right. Well, this looks like the end of the day, but there was some intoxication going on behind this aggravated assault
So,
of some sort.
yeah.
barbecued it with salad.
Yeah, something told me they were good.
And they've been putting some herbs and spices on the barbecue that this shouldn't have been.
If you
know what I mean.
The situation now, alcohol tends to enhance.
All right.
Food.
Yeah. Okay, what did the party say?
Your Honor, obviously, Mr. Johnson would beseech the court to continue his probation. I'm sure the state has other opinions, but I'll defer to Mr. Johnson to explain before his actions on the occasion question. Do you want to tell the judge what happened?
Yeah, I know I did two things wrong. I made a mistake. I left. I shouldn't have been out that Sunday night. And I was drinking. But two mistakes I know I made. I just want to do right by it, make up for my mistakes, do right by it. Seems like I ain't be getting no trouble doing nothing. I just happened that night I did that.
What were the circumstances of you drinking? No,
I had nothing. I went to a class meeting.
No one got stabbed. Huh?
No, I'm glad I stayed.
On that occasion.
I went to a class meeting. I probably seen it's my first class meeting. I ain't never been on this. 5 years ago.
I mean, do you see a consistent pattern though? When you get in trouble, it's always inebriation of
Here
some
we
sort.
reach what may be the central theme of the entire case: patterns of behavior. The judge is identifying a recurring link between intoxication and criminal conduct. Legally speaking, substance abuse isn't usually considered an excuse. It can actually become an aggravating factor when it repeatedly contributes to unlawful behavior. But there's another side to this conversation. Addiction and dependency are complex issues that often require treatment rather than punishment alone. The challenge for courts is determining when rehabilitation is likely to succeed and when public safety demands stronger consequences. What do you think? Is prison the answer, or would treatment have been the better path?
Inebriation of some sort, of a controlled substance or alcohol, and that. But you're fine otherwise. It's just, and you know it can lead to that. You gotta, I mean, you gotta be sensitive about. You've got a history. This seems to be the cause, but it's also your choice you're making, but that's a choice you need to change because it puts you in harm's way.
Poor judgment.
Stay.
All right. So on the positive side, Mr. Johnson made a good 3.5 years before he ran into this issue. Today, he's accepted his responsibility about the DWI. That's another positive for him. What's just I thought to myself when you made the comment that we wouldn't see him again. I was hopeful too, Judge. I mean, he hadn't been in trouble since 2009, which was part of the reason why I gave him the opportunity to successfully complete this probation. And I was hopeful that he would pay his restitution and we wouldn't see Mr. Johnson again. But here we are. And my knee-jerk reaction on aggravated assaults is that it's prison time is the best reaction.
When prosecutors begin discussing prison time openly, you know the case has reached a critical stage. The state points to a blood alcohol level reportedly 3 times the legal limit while already on probation. From a prosecutor's perspective, that's powerful evidence suggesting prior interventions may not have worked. At the same time, the defense highlights years of employment and compliance. This is where sentencing becomes incredibly difficult. Judges aren't just deciding what happened. They're deciding what response best protects the public while remaining fair to the defendant. And that balancing act is one of the hardest responsibilities in the justice system.
Reaction. In the event that the court is not considering that, I would ask that whatever we do, that it be a strict message that comes to him. Someone who ends up with a 3 times the legal limit of a DWI while they're on probation is very telling. And to me, the only way that he stays on probation is if he goes to safety. Of course, I always defer to Your Honor. I will tell you that when I considered the amount of pen time, I made the offer to the defense of 7 years. So.
Go ahead. from the defense.
I prefer to go to Mr. Johnson. I think the court has all what it needs before to make a decision. Obviously, he's maintained employment. He's done the other things on probation he's supposed to do. Appreciate Mr. Ham's already ended up the substance abuse issue. And I'll just defer to the court if the court continues to ask the court to continue on probation with whatever sanction. You do have available upfront time. You also can revoke the deferred status. He doesn't have a TDC conviction.
I don't think it. No, we can't.
Oh, well, that's true.
Yes,
So you can't put it on strike.
Aggravated. There's a deadly weapon.
So it would have, you'd have to continue on the deferred. You do have available the upfront time sanction, but
And from the probation office, I always appreciate your input.
Yes, sir. So it just seems like there's a substance abuse
Yeah.
issue that needs to be addressed. He also tested positive for alcohol on December 17th as well in my office. And I believe he told me that he got in an argument with his sister or something was going on during that time. And he had one twisted teeth on that date.
Oh. Anything else?
we rest.
Sir, anything you'd
Listen
like to
carefully
add?
to the probation officer's testimony because it's often some of the most influential evidence in revocation hearings. Probation officers see defendants over extended periods and can provide valuable insight into patterns, compliance, and risk factors. Here, concerns about substance abuse continue emerging as a consistent theme. What's striking is that multiple sources, criminal history, probation records, and current allegations, appear to point toward the same issue. When separate pieces of evidence all tell a similar story, judges often view that as especially persuasive. By this point in the hearing, you can sense that the court's decision is rapidly approaching.
Sir, anything you'd like to add before I make the decision?
I just give me a chance to do right. No, that's not anything.
I did. I mean, put you on probation.
That was first, I got on probation.
I know, but you've got 5 prior convictions. You've got
Those are old.
three misdemeanor convictions, substance abuse, all based on substance abuse, except the tampering with government records there. And then possession of a controlled substance that we placed you on probation in 04, and that was revoked in 09, and 8 months. Then possession of marijuana again, six months, state jail in 09. And then here you are, and it's inebriation of a sort. Whether it's alcohol or drugs, it's still dangerous, and it causes you to make errors, which has been consistent. But you've been put in prison facilities before, and that would I would think that would change me, certainly. But you've done it 5 different times.
And that's no drug no more.
It's still, you're here. And not following the rules, and it's an intoxication again. You're not thinking sober thoughts.
Laid out their time.
And acting it out. If nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegations 1.
This may be the defendant's final opportunity to persuade the court. Sentencing hearings often come down to one question: does the judge believe meaningful change is possible? The defendant asks for another chance, while the court reviews years of prior convictions and repeated substance-related problems. It's a sobering moment because everyone in the courtroom understands what's at stake. Judges frequently talk about accountability not because they enjoy imposing punishment, but because they believe consequences can sometimes encourage change. The difficult reality is that second chances are valuable, but they become harder to grant when prior opportunities haven't produced lasting
Allegations
results.
1 and 4 have been proven true by preponderance of the evidence or greater, by beyond a reasonable doubt in driving while intoxicated, and you were at a location other than your residence at the curfew on that December 26th day. And that is enough to grant this motion to revoke unadjudicated probation. And your deferred or unadjudicated probation is hereby revoked. Earlier, in this case, you had pleaded guilty to aggravated assault, second-degree felony, voluntarily.
The court has now formally revoked probation and entered a conviction for aggravated assault. Legally, this is a major turning point because deferred adjudication had previously allowed the defendant to avoid a conviction if conditions were successfully completed. Once revoked, that protection disappears. The judge also makes a deadly weapon finding, which can carry additional consequences beyond the sentence itself. Yet notice something interesting. Despite the state seeking 7 years and the law allowing up to 20, the court imposes a 3-year sentence. That suggests the judge weighed both aggravating and mitigating factors before reaching a decision. Sentencing is rarely as simple as punishment alone.
Voluntarily, knowingly, intelligently, there was sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted in that hearing to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of that aggravated assault, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time you have served. Also, the judgment shall reflect that a sharp object, a deadly weapon, namely a sharp object, as it is stated in the indictment, was used in the commission of this offense. And the indictment goes on to allege that you pleaded guilty to that sharp object in the manner of its use and intended use was capable of causing serious bodily injury or death, which is the definition of a deadly weapon. So that's going to be placed in there. The state had asked for 7, and you were looking at 20, up to 20.
What was the maximum grade you're on from him?
It's more, not much, 28.
Yes.
It's nothing. And
The PSI.
yes, sir. Do you understand what has happened today, sir? Yes, sir. You're going to get all time that you've been credited for, and hopefully this will pass and just move on and do better. Thank you.
This case serves as a powerful reminder of how probation operates within the criminal justice system. Courts grant probation as an opportunity for rehabilitation, but that opportunity comes with strict conditions and expectations. In the first case, the court struggled with trust, repeated allegations, and unresolved evidence. In the second, admitted probation violations, including a DWI and curfew breach, ultimately led to revocation and a 3-year prison sentence for aggravated assault. The judge repeatedly emphasized accountability, family responsibility, and the consequences of repeated substance-related behavior. Whether you agree with the outcome or not, one thing is clear. Courtroom decisions are rarely based on a single mistake. They're often based on patterns built over years. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.